Welcome, everybody, to the May 21st, 2015 Zoning Board of Appeals. We have 3 matters on tonight. 2 are going to be very short, so we're going to take things out of order. We're first going to take our second application, which Town Council is here on, and would you like to read that?
Absolutely, Sarah. Second application continued from April 16th, 2015. Request for the Zoning Board of Appeals to review changes with regard to the comprehensive permit issued on January 16th, 2003 to Stockbridge 2 Realty Trust. The project is located at 90 Stockbridge Road, Assessor's Map 054, Block 2, Parcel 27.
Good evening, Mr. Toomey.
Good evening, thank you. What's involved in what you have before you tonight is the approval of the record plans for the 40B. These require substantial revision, largely because of an issue that the Conservation Commission came up with, which was showed that the detention basins were actually in a Zone A of our water supply. So there was significant revision in terms of moving the basins around and reconfiguring the drainage. That's been done. We've been working at this with roughly a monthly meeting since, I think, last February.
Yeah.
Plans are sufficient to meet the requirements of the drainage management. John Chessier has reviewed them and worked with us and with the applicant to make sure that everything has been covered. The only issue left is that some of the construction details still need to be put into in the plans, things like where the utilities go, water, electricity, and so forth. So I prepared a motion which would approve the plans, but make it subject to the detailed plans, which then I would have reviewed and approved by the building commissioner prior to the issuance of a building permit, so that those details are done properly. So that gives you, in a nutshell, what has taken us about 7.5 months to get accomplished, but it's done at this point.
Excellent. Does any of the board members have any questions regarding? No? Anybody from the audience wish to be heard on the Stockbridge Road matter? Yes, sir.
So, did they move the septic system out of the Zone A?
They did.
Okay. Anyone else?
Well, given that we have a report from our consultant and the many hours of effort put into it, I'll move that the board vote to endorse the applicant's plan as currently submitted and dated May 5th, 2015, as complying with applicable stormwater requirements and the requirements of the comprehensive permit, provided additional revisions showing full construction detail shall be made and approved by the building commissioner prior to the issuance of a building permit.
That date is wrong. It should be March 29.
Amend my motion to say March.
The
25th.
the plans you're talking about?
Yeah, March 25th. John has looked at them to make sure we got the right ones.
Okay.
I'm sorry.
Amend the motion to be March 25th, 2015.
And then we will get the plans back with Mylars, which will include that a notation on them, so we're clear, and then they'll, at some point, you'll have to endorse the actual Mylars.
Second.
Second motion, all in favor?
Aye.
Thank you very much.
Thank you.
Good luck.
Good to see you all.
Yep.
See you, Paul.
See you.
We don't even need to do anything.
No, that's all.
Yeah, that's no decision. Okay. You want to come and do the thing? Okay, we'll do the last for the status request. That's the other short matter.
Shall I read it?
Sure.
Request for status update, South River Partners, LLC, and Scituate Affordable Housing Trust. Construction at 163 Stockbridge Road.
Madam Chair, members of the board, my name is Mike Salamando, and what we hear about, my counsel's not here today. He should be, but I don't know, something must have happened, but what we came, just to give you a status on the affordable housing unit that we're putting in on 163 Stockbridge Road. The house is framed, and it should be completed and ready for occupancy in another 60 days. We're just, and one question that's been going back and forth is when, who is the eligible buyers, or if the Affordable Housing Committee has an affordable buyer that would like a three-bedroom home with a garage, a single garage, and who's, or what is the process for getting someone in?
Oh, boy. I know that they go through somebody in town hall. Is it the Affordable Housing Committee?
Yes,
Oh,
we have to...
because you're on that,
Was.
aren't you?
But yeah,
Oh,
I'm still
was.
familiar.
Okay, perhaps you can address that.
Yeah, I think most of, they did have a list, we'll have to see if it's updated, so we might have to reconfigure the list and put another one out if that list isn't current. But I believe we had put 163 on the original list, so it will probably still be qualified. We just have to check the dates on it to see if it go out. If not, we'll have to do another lottery and go that way. But still at the time, we could still pull from the old lottery.
We have pulled the water, all the street connections have been made, and the utilities are into the lot, and then we're going to branch it off up to the second lot that we don't have anything to do with. Just all that is in process, and we're. But like I said, we're probably about 60 days out from having fully completed.
Do we have a deadline on that? I don't remember.
Not really. I think it's like sometime, I think the end of 2015.
Okay, good.
I
Yep.
think it's there.
Excellent.
It looks good so far.
Yeah,
I
just to
I
go
meant to
by.
drive by and I didn't get a chance to do that.
it really is quite, it can really house, the bed, the rooms are big.
Good,
The rooms are big.
excellent. Well, we're sorry to have missed Attorney Sullivan. Anybody have any
I know,
questions?
I'm a little nervous, but.
He's, yeah, well, maybe it's traffic. Traffic has been terrible today, so. Does anybody in the audience have any comments or questions regarding the affordable housing unit at 163 Stockbridge Road? Okay,
Thank you.
thank you.
Appreciate the
We'll
update.
look forward to when it's complete. Okay.
Now for the real fun games.
Okay. Madam Chairman, first application continued from March 19th, 2015. Kenton L. Bungerzone of 17 Gates Circle, Scituate, requests a variance in accordance with Mass General Laws, Chapter 40A, Section 10, from Section 520.4 of the Scituate zoning bylaw, requiring a 150-foot no-disturb buffer zone from a tributary to allow construction of a single-family dwelling at 5 Williamsburg Lane in Scituate, Mass.
Hello again.
Good evening, everyone. My name is Adam Brodsky, and I represent Kenton Bungerzone, the applicant. I'm here with Greg Morse, our professional engineer, as well as the Bungerzones who are behind me. We did have a homework assignment after our last meeting, which was to brief in more detail the issue of substantial hardship, and that information is contained in my May 8, 2015 letter to the board. I have extra copies if anyone would like, as well as the relevant cases. With your permission,
May I interrupt just for a moment, please? Madam Chairman?
Yes. Oh, yes, I'm sorry. We did have an issue that we want to clear up, Mr. Brodsky.
Of course, please.
One of the comments that we received was apparently there has been circulated a petition to have Ed recuse himself, and so he's going to speak to that issue first before we get anywhere.
I think we've received a lot of communication on this application before us, but there wasn't a 6-item petition that was circulated within, I believe, the neighborhood. And Item 6, I'll read it. It says, "A conflict of interest exists. The Zoning Board of Appeals member, Edward Tibbetts, is also a well-known realtor in town. He could potentially benefit from the development of more new home in Scituate, as he would make a commission on the sale of the new houses. He and Mrs. Elaine Borngazone clearly work in the same industry in a small town with similar vested interests in seeing this variance get approved. He knows more than anyone that Mrs. Borngazone does not have an economic hardship. She was listed as one of the top 20 realtors in Boston in 2014. Mr. Tibbetts had already decided to approve the variance without listening to any input from the public, and was clearly biased during the last meeting on this issue. It is unethical for him to sit on such a board, and he should recuse himself from this case before the Board of Appeals." First, I take umbrage to the suggestion that I would sit on a board where there was any conflict of interest without disclosing it. I've been on the board on and off for close to 15 years. I've never been accused of conflict of interest. I have recused myself, I think, on 2 occasions, both up front long before the testimony took place. I appreciate that I am a well-known realtor in town. I find that quite humorous, to be honest. My father was a builder in town, built probably 150 or so houses in the town of Scituate. My mother was a well-known realtor in town. Both of them are now deceased. I teach middle school. I've been doing it for 15 years. That's my primary occupation. It has nothing to do with being a realtor. My wife, who moved to town 10 years ago when we married, obtained her realtor's license, and I was told that I needed to activate mine, which I've held since 1988, in order to consult with her and not be violating the provisions of MLS as perceived by Caldwell Banker. This is not an advertisement for my wife's or my realtor ability as realtors, but yes, I am somewhat peripherally engaged in the sale of real estate. I don't know how I know more than anyone that Mrs. Borngazone does not have an economic hardship. And in fact, I don't think an economic hardship is based on whether or not an individual is successful in their chosen profession. An economic hardship with respect to an application before us has to do with whether the application, the individuals in the prosecution of their application are going to be adversely affected. It's the same standard we have for everyone, no matter what their chosen profession is. Quoting the summary of the Massachusetts municipal law for municipal employees, it says that an appearance of conflict acting as a member in a manner that would make a reasonable person think you can be improperly influenced is prohibited. And as an example, it says, requires that the municipal employee be to consider whether his relationships or affiliations could prevent his or her from acting fairly and objectively when he or she performs her duties for the city or town. There is an example here that's given as no violation. A developer whose cousin is the chair of the Conservation Commission has filed an application with the commission. A reasonable person could conclude that the chair might favor his or her cousin. Well, I don't think we have that kind of a relationship, but even in that case, something as close as that, the chair simply needs to file a disclosure of their relationship with the appropriate authority. I don't feel that Mrs. Borngazone or I have any relationship close enough to file any kind of a disclosure. I don't think that my being a licensed realtor in the Commonwealth of Massachusetts and acting in the towns suggests that I am going to benefit from the sale or the building of one home. I don't think that any of the attorneys on the board are going to be benefited by the fact that real estate actions tend to be presided over by members of the board, of the bar. This is a stretch, and I'm personally offended. I take umbrage to it, but I will yield to the decision of my colleagues or the applicant if they feel that there is anything that would preclude me from making from acting in an unbiased manner on this application.
Does the applicant have any objection to Mr. Tibbetts sitting?
No, we don't see any conflict of interest whatsoever, let alone an appearance of impropriety.
Ms. Mongazzo?
Only about the 17 Gate Circle, I too take offense. The only thing is, I'm very flattered that anyone would think I'm one of the top 20 realtors in Greater Boston. Okay, I am so flattered, but it makes me wonder when you come out with something like that. It's not true. I mean, show me where I am, because I wish I was. But then I question other things, because I can tell you now, far from one of the top 20 realtors in Greater Boston.
Well,
It's inaccurate, totally.
Okay. I certainly don't see
I
any,
am one of the best, most well-known realtors in town, though, I can appreciate that.
you know, with all due respect to petitioners, as I understand the conflict of interest laws in Massachusetts, Ed does not have a conflict, and you will not be stepping down. I don't want to make this a big issue. I'm going to really have maybe the only comment from the audience. Yes, ma'am. So you have to stand up. Let me just, you know, it's, there's quite a few people here. It's not, you know, standing, I mean, you know, it's packed, but if anybody wants to speak, once you're recognized by the chair, just stand up, give your name and address, and then you may speak.
My name is Dana Duggan, 18 Williamsburg Lane. I'm the one that circulated the petition. I found all of the information in there online. And I want to say, I want to submit 12 more signatures today, which brings my total of signatures on the petition close to 40 signatures. So these are 40 tax-paying citizens that do agree with point number 6, that it is a conflict of interest, because he is a realtor, Mrs. Bungazone is a realtor, and I'm not specifically speaking about this one house that will be for sale, but I'm talking about if they get this variance and can develop all of the other lots that they own on Williamsburg Lane.
Okay, you know what? You're going to have time to talk. The issue right now before us is the conflict of interest. We don't see any. The applicant is fine. The board doesn't see any, and you'll have an opportunity to talk to, just, you know, make your comments about the application a little bit later on in the...
We'll move on from this.
Okay, thank you. Okay. All right. With that, you know, I'll leave it to you, but we do have quite a few people that haven't been here. I was thinking that it might be beneficial to do an overview of your case, okay? And, as it were, of your application and the points. What I would like to do is to, for the record, read the bylaw that you are seeking a variance from, and then look at, you know, read the statute, so it's understood what's at issue here. There has been a lot of stuff, you know, circulated and questioned, and a lot does not have anything, you know, a lot of the comments, just quite frankly, don't have anything to do with this application. And so I want everybody to start fresh and have an understanding what the issues are in this case, because some of the issues that have been raised are not issues in this. So 520.4 of the bylaw is from the Water Resource Protection District, 520 from the zoning bylaws. 520.4 refers to the buffer zone. Non-disturbance buffer zone. A non-disturbance buffer zone shall exist 150 feet horizontally from the high water mark of Tack Factory Pond Reservoir and from the edge of all tributaries in the reservoir watershed. Within this buffer zone, in addition to all other restrictions of the Water Resource Protection District, the following additional activities are prohibited. 1, any activities which cause earth movement or disturbance. 2, vegetation removal or cutting. 3, construction or placement of any permanent structures other than those associated with the providing of public water. And 4, any surface or subsurface discharge, including but not limited to stormwater runoff and domestic or industrial wastewater. So, the short story is you'd like to build within that buffer zone. and that is going to require a variance. And the Zoning Board of Appeals is called in the statutes of Massachusetts the permit granting authority. Sometimes the permit granting authority might be the planning board, but in this case it's the zoning board. The permit granting authority shall have the power, after public hearing for which notice has been given by publication and posting as provided in section 11, and by mailing to all parties in interest, to grant, upon appeal or petition with respect to particular land or structures, a variance from the terms of the applicable zoning ordinance or bylaw where such permit granting authority specifically finds that owing to circumstances relating to soil conditions, shape, or topography of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located, a literal enforcement of the provisions of the ordinance or bylaw would involve substantial hardship, financial or otherwise, to the petitioner or appellant, and that desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of such ordinance or bylaw. And there's a little bit more to it, but I don't think it's applicable particularly. So that's what you're seeking. This is the standard. So if you want to just, give us a run through.
I'll do my best to see if I can remember all of these details. The subject property is 21,461 square feet, over 125 feet of frontage on Williamsburg Lane and 104 feet of frontage on Country Way. The property complies in all respects with the lot area and width requirements for lots in the Residence 2 zoning district. The property was acquired by R.M. Bargazone, Inc. in 1955. That was Kent Bargazone's father's company, and subdivided in 1956. So this has been a lawful lot conforming under zoning since 1956. In 1970, Kent's father granted the town a drainage easement over the property for municipal stormwater for $1 consideration. The town, in reliance upon that easement, replaced an existing iron pipe with a new concrete pipe, which daylights to a new concrete head wall, which is located on the property. From that head wall, there was a man-made drainage channel or swale that then ultimately leads to the town reservoir. That head wall is more than 1,000 feet away from the town's public water supply. Kent inherited the property when his father passed in 2000. In 1987, so this is 20 plus years after this lot was created, the town adopted the Water Resource Protection Bylaw. The purpose of that bylaw was to prohibit uses such as sanitary landfills, salvage yards, junkyards, and those kinds of commercial uses to protect the town's water supply. You may recall that I presented to you some of the information from the town report where there were specific discussions about the creation of this overlay district and the fact that it was not intended to interfere with residential use in any of the districts. In connection with that bylaw was the creation of the 150-foot non-disturbance buffer zone, any tributary. In 2011, you may recall that Mr. Bargazone actually obtained his permit to construct a single-family house, a driveway, and an on-site septic system on the property. At that time, that man-made drainage swale was not designated as a tributary. The town and everyone involved in the project understood it to be a wetland regulated under the Wetlands Protection Act. The septic system was approved by the Board of Health. That was a conventional septic system in 2012. and Mr. Bongazone received an order of conditions from the Conservation Commission as well as the stormwater permit in 2012. And for personal reasons, the Bongazones did not build the house that was permitted in 2012. Thereafter, in connection with an unrelated project at 305 Countryway, DEP reviewed that wetland, essentially it was an intermittent stream, and determined that it was not a stream regulated under the Wetland Protection Act, but in fact was a tributary regulated under the Massachusetts Water Protection Regulation. So the resource area changed from what had been delineated by professionals to a tributary. It's important, we're not challenging the fact that there is a tributary with a head wall on the property, and we're not challenging the fact that we're within the Water Resource Protection District. Mr. Bongazone is voluntarily re-permitting the project. He needs to construct an on-site septic system. Title V has a specific requirement for locating septic tanks and soil absorption systems from tributaries. Is a 200-foot requirement. However, the regulations expressly provide that you can get a variance from Title V to reduce that setback to 100 feet. So Greg substantially redesigned the system in order to comply with the 100-foot setback. I should note that the entire property is located within that 200-foot setback under Title V, and the entire property is located within the 150-foot buffer zone under the Water Resource Protection District bylaw. In order to obtain that Title V variance, we needed to demonstrate to the Board of Health that we were providing the equivalent environmental protection. And so what we have proposed doing here is a substantially different system. It's a microfast denitrification system. It's designed such that it's going to reduce nitrate nitrogen, which is the principal pollutant that you're concerned with an on-site septic system in proximity to a public water supply, actually less than 10 parts per million. 10 parts per million is the maximum concentration level. At the property line, with the system working, the effluent from the septic system will actually meet drinking water standards. If you compare that to a conventional septic system, and we did all of the nitrogen loading calculations to prove this to the Board of Health, my recollection is that a conventional septic system would generate approximately 19.1 parts per million at property line. We're providing an order of magnitude greater environmental protection, which is what we needed to do to get the Board of Health to grant us that relief. With the Board of Health is the permitting authority in the town with expertise in these issues, and ultimately decided to grant us that variance from Title V, allowing the construction of that on-site septic system. Since we were also doing construction activities, the removal of vegetation, earth movement in connection with the project, we also need a variance from the requirements of your bylaw, because again, the entire property is located within the buffer zone. We presented substantial information to you demonstrating that there are circumstances relating to topography and to a certain extent lot shape which warrant the granting of the variance. Greg explained to you the unique conditions related to that property, and I'm going to have him do that again because that was some additional information that we generated. We demonstrated to you that little enforcement of the bylaw would cause substantial hardship to the boundary zones. I'm going to talk a little bit about that tonight, and my goal this evening was actually to speak as little as possible because Greg has additional technical information, and I know that you want to hear from butters. And it's clear that granting relief is not going to cause substantial detriment to the road. The whole purpose of the Water Resource Protection District bylaw is to protect the public water supply, where there's going to be no adverse impact whatsoever for the construction of a single-family home at this location with a state-of-the-art microfast technology system. And Greg will speak to that in more detail. So, you've got a series of letters from me, the last being my letter from May 8, 2015, And what I'd like to, I'm very briefly going to touch on a couple of key points. With your permission, over the last several days, I've received a stack of information from concerned citizens. I'm not going to address this in any great detail, but I would like permission to just briefly touch upon, I think there are 10 or 11 key points. I'm going to keep my comments to a minimum. But more importantly, Greg is going to, I'll ask him to revisit the unique conditions. He's done some additional research regarding the district generally, and I'll ask him to do that. So just quickly with respect to my letter, I was specifically asked to address and provide a legal brief as to the issue of substantial hardship. But I know that there were some questions regarding what does it mean that there must be circumstances owing to topography and generally not found in the district. The two districts that were concerned were in the R2 zoning district, and we're obviously in the Water Resource Protection District, and more particularly within the subzone A. And I found out from my research, what generally means is generally. And that is that we don't need to demonstrate that we're the only lot within those zoning districts with these unique conditions to justify the grant of a variance. However, having said that, Greg has done extensive research, and he's going to explain to you that this is in fact the only lot within the R2 zoning district and the Water Resource Protection District subzone A that would even be eligible for a variance. And obviously that's important. The board's concerned about creating a precedent, but we need to demonstrate that in fact we have unique circumstances relating to topography and lot shape in order to justify the variance. The relevant cases are Planning Board of Watertown and the Mar-Hefka case. I found the Mar-Hefka case interesting. It was a trial court decision dealing with a variance granted. And it's interesting that the trial court actually looked at the properties on either side of the subject property. Didn't really take a comprehensive look.
I'm sorry, is that a new case that you just came up with?
Mar-Hefka case is a 2007 trial court case. And
I see it, land court case.
Yes.
Okay, got it, I've got it.
2013 Westlaw 129-410. It's not an appellate decision. But I did provide with you the Planning Board of Watertown versus Board of Appeals of Watertown, which is an appeals court case, filed in Mass Appeals Court 833. It was just interesting that the land court, the trial court, actually kind of focused on the lots to either side, and that was sufficient for that determination. With respect to the issue of substantial hardship, I think the cases are pretty clear. It's found where the property is not able to be developed for permitted use. That's the Holdings case. And in this particular lot is unbuildable without the grant of the variance. It has been zoned for many decades now as a residential lot. It meets all zoning requirements. And it can only really be used for residential purposes, denying Mr. Baumgartner the ability to construct a single-family home on a properly zoned residential lot prevents him from using the lot in a conforming way under the bylaw. So I think that's all spelled out in detail. I have extra copies if you'd like that, but you asked me to provide you with the cases that support those propositions of law. If I can just briefly address some of the major themes of concerned citizens. We understand that these are neighbors and other interested parties, and they're well-intentioned. I think they may be misinformed in certain respects. I just want to clarify things, and this is in no particular order. The first is, I've already mentioned, that there's no dispute that we're treating this as a tributary, whether it's man-made or naturally occurring, and there's no dispute that we're located within the Water Resource Protection District, which is why we need relief. We respectfully disagree with the suggestion that this variance is going to lead to more development. As Greg is going to tell you, this is actually the only lot that you could actually develop within the R2 zoning district, as well as the WRPD subzone A. some concern regarding the use of the microfast technology. This is a proven and reliable technology. It's been approved by DEP since 1995. It's been used successfully throughout the town in many towns. And in order to justify the Title V variance, we're required to record a deed restriction, which actually requires a maintenance contract to be maintained in periodic reports. So this is a proven technology, and the Board of Health made sure that we're going to have to maintain this technology. There was some suggestion that we're installing a treatment works regulated under some of the other regulatory programs. I just want to be clear that this is a Title V system. It's not a treatment works regulated under either 314 CMR 3, which is actually a surface water discharge permit, or 314 CMR 5, which is a groundwater discharge permit. It's kind of difficult sometimes to read the bylaw, and so there's a section relating to treatment works that doesn't apply in this instance. And as I mentioned, Title V allows us to locate the system 100 feet from the tributary, provided we provide these additional environmental protections. The highest and best use of this property is, under any appraisal methodology, is as a single-family residential dwelling. The property's been taxed as residential. There's some suggestion that the highest and best use would be some other use, such as open space, and that's simply not accurate. There's no zoning change related to the lot. There was some suggestion that there was a zoning change that the butters weren't notified about. We're not aware.
Not an issue.
There's a suggestion that although the butters were not notified, all of the butters that we were required to notify under Chapter 40 was done. Property is not mapped as priority habitat regulated under the Massachusetts Endangered Species Act. There's minimal wildlife habitat value to this. It's a previously altered suburban lot. Having said that, just as an indication, the Conservation Commission is charged, among other things, with the protection of wildlife habitat. That's one of the interests protected under the Wetlands Protection Act, as well as the Scituate Wetlands Protection Bylaw. And you'll remember the Conservation Commission granted an order of conditions for the same project. So the Conservation Commission, which is concerned with wildlife habitat, has already reviewed essentially this project. We obviously no longer need that order of conditions because we no longer have a wetland on the site. We have a tributary. But I think that just gives you a sense that that issue has been reviewed by the town. We obviously don't believe there's any conflict of interest. And the main issue is that there's going to be no impact whatsoever to surface water quality. As I explained, we're specified the microfast system, and it's really kind of unique. So that line, effluent septic system, drinking water standards for nitrogen, and even given that we're at a substantial distance from the public water supplies, so you have the natural degradation of any contaminants, but we needed to make sure that we were providing the utmost environmental protection here. Point out that obviously surrounding us are existing conventional septic systems, some of which likely have not been upgraded to meet current Title V standards, and so those septic systems likely pose a far greater risk than this state-of-the-art system. The Board of Health has extensively reviewed the issue and found that we've provided the equivalent environmental protection. In fact, we've provided more and better than the equivalent protection. We're cutting that effluent MCL to less than 10 parts per million. I guess the point I'd leave you with is that there's actually no scientific evidence that has been presented to this board that the project in any respect is going to adversely impact surface water supply. We've indicated to the board that if you have concerns with things like fertilizers and pesticides, that we would certainly agree to reasonable conditions and restrictions on the use of those if you thought that that was a concern here. There are obviously no other restrictions on any of the properties in the general area. But we presented to you, testimony from Greg, a well-respected professional, demonstrating that there will be no adverse impact to surface water. And with that said, I'd like to turn it over to Greg to perhaps review more of the technical issues.
Good evening, Greg Morse, registered engineer, Morse Engineering. Oh, if you need, do you feel like you need a quick overview of the site again, just to refresh your mind?
If you want.
The site plan that we submitted, just for everyone's benefit, the property line
Right.
here is shown.
Could you work as comfortably if you stood to the other side so that the audience can see it? There's no question, we don't have to go back and repeat.
The property line is shown here in bold. Country Way is on the left side of the plan here. Williamsburg Lane is at the bottom of the plan here. I highlighted in blue the limits of the tributary and the head wall at the back of this site. As Adam mentioned, that tributary is fed from a drainage pipe. You can see that runs here across the site through an easement out to a series of catch basins within Country Way. So it's municipal stormwater that's coming down, creating this tributary. In the distance from this location that the water travels is approximately 1,600 feet before it hits the reservoir. From that tributary, the town has the 150-foot no-disturb zone. That no-disturb zone I've highlighted in pink. As you can see, it includes the entire buildable portion of this lot. There's essentially no area on the lot that you could build outside of the 150-foot no-disturb zone, which is what brings us here for the variance. We've cited a house at this location. The house is brought up to the 30-foot front yard setback. It is a 3-bedroom house. We have proposed dry well systems, we have proposed rain garden systems, and we have proposed a 50-foot vegetated buffer from the tributary with our limit of clearing. The septic system, again, as Adam stated, is 100 feet away. It has been approved by the Board of Health. It is a fast nitrogen reducing system located right here. After our last meeting, the board asked that I look into the uniqueness of this lot, specifically with regards to the zoning district. And so what I did is I looked at the current Scituate zoning map, and I've brought a portion of that map to present to you. This represents the R2 zoning district with the Zone A overlay on it. And to familiarize you, acclimate you with this plan, this black line here represents the divide between the R2 zone, which is the orange color, versus the R1 zone. The R1 is kind of this lime green color. Our site, this green line right here, represents Country Way. Our site is right here on the plan, this being Williamsburg Lane. What you'll notice on this plan, you'll notice that there are 4 locations, 1, 2, 3, and 4 fingers, if you will, of Zone A that extend into the R2. This finger up here, the Zone A, touches a total of 15 lots. All 15 lots have been developed and built upon. This cluster here, you'll see where the Zone A comes up at the corner of Williamsburg and Country Way. It touches a total of 7 lots. Of those 7 lots, 6 of them have been built upon. The only one that has not is the client's property. This finger here that extends into the R2 has a total of 36 lots on it. Of those 36, 32 of them have been built upon. 4 of them I would classify as not buildable. Not buildable due to significant wetland issues or due to lack of frontage on a public way. And the last finger down here touches a total of 19 lots, 18 of which are built upon, the one remaining lot being unbuildable because it lacks frontage on a public way. It's a landlocked piece of land. And so what I looked at with the uniqueness here for the applicant's lot is that when I look at the total here of 77 lots that are within the R2 Zone A, of the 77 lots, there's only 1 lot, the client's lot, that could be a buildable lot. These other ones have significant wetland issues or have significant frontage issues and lack the appropriate land area to be considered buildable.
What about the other lots on Williamsburg Lane, Christopher Wren, and
Sure. So,
or something, Barton?
yep, so those are not located in the R2 zoning district. Those are in the 1 acre R1 zoning district. I did receive the analysis there from Laura Harbottle. It looked like she identified 4 lots out back. I would, in my rough analysis of that, I would say all 4 are unbuildable. One of them lacks frontage on a constructed public way. The other 3 have significant wetland issues and wouldn't comply with the upland land area requirements.
And I should just reinforce that Laura actually reviewed the R1 zoning district, not the R2 zoning district in which our lot is located.
Excuse me, I disagree with that.
Okay, but is the issue here the Water Resource Protection District, or is the issue here the R1 or R2 district?
Well, we agreed that with you, the board said it's both. It's the R2 zoning district, which is the underlying zoning district, overlaid with that portion of the Water Resource Protection District that falls within the R2 zoning district. So that's why we've been analyzing both. I should remind the board, and maybe Greg, you just describe why the lot is unique. It's something we haven't discussed this evening, but we should just remind you of that.
Sure, we were, the lot itself, we classified as unique due to the topography of the lot. And what I showed you last time was I showed you the general topography in the area of the lot on a USGS map, and that's when I believe the board asked for specifically focusing in on our zoning district as opposed to our watershed area. I agreed at the last meeting, I thought that our watershed area would have been a better area to analyze, but the way the law is written, it appears it was our zoning district that we needed to look into. But looking at the topography at the USGS map here, what we noticed in this location was that the majority of the lots over here have a constant slope across them. Okay, so they're constructed with one plane, and what that results in is stormwater, rainwater coming across the lot in a sheet flow condition. Our lot is unique in the fact that there has been a channel carved into it. Man-made or natural, there has been a channel carved into it, and because of that channel and because of the 2 planes converging, that is where you have the accumulation of a intermittent stream or a tributary area. More importantly, without the location of that stream channel on this property, you would not have a tributary area. You would not have a tributary to the water supply without those 2 planes intersecting on this lot.
And I think the reasonable inference is that's why the town located that municipal storm pipe, because it's the lowest point in the system as a result of those natural features.
We're not taking questions from,
I didn't ask one.
no, it's somebody behind you, yeah.
Oh, sorry.
Oh, good. But are we permitted to ask a question on the presentation that was just given?
I think we'll wait. I
Okay.
think we'll wait. But keep it back there.
It's like the NFL.
That's right. Worse, trust me.
So we've met our burden of proof on each of the 3 prongs of the test under 48 section 10. And just to be clear, I just pulled a copy of the statute. The statute is, but not affecting generally the zoning district in which it is located. That's the language of 48 section 10, which is why we've analyzed this as such.
With that, does that conclude the applicant's?
Yes, we may have some additional information in response to comments from the concerned citizens, but that's substantially all the additional information we have for you this evening.
Okay, so, how would the board like to proceed?
Questions or?
I have a question.
Okay, there you go.
All right. How many other lots are within the buffer zone around that tributary?
How many lots? All of them? You mean you're talking about,
Within the buffer zone of the newly discovered tributary?
Just in this one location, or the whole Zone A?
Within the 150 feet?
Within the 150 feet?
Yeah.
1, 2, 3, 4, 5.
And they're all built, right?
Correct.
you're talking about just that finger, though?
Yeah.
Okay.
That was my question. Thank
That's
you.
your only question?
So far.
So far, okay.
It largely, was the same area I was wondering. We have a situation where a tributary that's being fed by roadway runoff is in jeopardy because of the possibility we might allow the building of one house where there are already 5 existing houses with systems that probably date back to the 60s, many of which are significantly less successful at taking care of nitrates. And the applicant's system is going to create effluent that's drinkable before it reaches the lot line.
No, it just doesn't have nature.
Excuse me.
Yeah, I'm sorry.
Drinking water standard, meets drinking water standards, I think is what?
For nitrates.
For nitrates. For nitrates, all right. But the other 5 lots aren't held to that same standard. And the town's surface runoff from the roadway is certainly not held to any standards. I'm not familiar that we have a no salt zone on that part of the roadway. And at least from my experience with concerns for public drinking water in other parts of town, we do have no salt and other things that aren't applied here. And the standard for variance is whether or not a property owner is being unduly burdened in the application of the zoning bylaw. Or in this case, the Water Resource Protection Bylaw. And I'm trying to look at it from the same standpoint I would for any property owner in the Commonwealth of Massachusetts, or at least in the town of Scituate, on whose board I serve. And I've looked to protect their rights while maintaining the sovereignty and sanctity and quality of our water. I would not put that at jeopardy. But that evidence of 5 existing houses with septic systems within the same area, I question whether or not building this one as proposed is detrimental to the public good. And that's what I'm wrestling with at the moment.
Yeah, I guess the counter to that, Ed, is that they were already built. The Water Resources Protection Law passed after that. This one wasn't built, and the idea was, I think, not to build any more to threaten the water supply anymore. I don't think it makes a difference personally. Well, I guess personally is not the right thing. I don't think it makes a difference or should make a difference what the Board of Health does or doesn't do, because that's really a separate issue, the whole Title V issue, and whether these other lots are compliant or not. You know, they should be compliant. I can tell you, having served on the Board of Health for many years, a fast system is probably the best compared to all of these other systems that we have in the town, so you could drink the water. That's the way they're designed. But I think that's the baseline, is that whatever is built certainly shouldn't do anything adverse to the water supply. My question is the bylaw seems to talk about more than that, and I asked this question the last time. It talks about, the importance of maintaining vegetation. It talks about the importance of not having structures there, the idea being that you want to leave as much land pristine to sort of filter rainwater as it gets into the ground and then moves on into the reservoir. So we're going to have that here. I mean, by definition, it violates the water resource protection provisions. And I guess the question is how unique is this property? Because I think once you get to the unique question, then the hardship question naturally follows. If it is an unusual situation, the hardship has to follow from the unique circumstance of either soil or topography. It doesn't have anything to do with whether a particular person is wealthy or not wealthy, or able to afford it or not able to afford the loss. It's flowing from this unique circumstance. Is there a hardship that's encountered? And so I think you've addressed the case law pretty well. I think it naturally flows from that. So the real question is this so unique that the variance, which is rare, which is not, I won't say rarely, but which is reluctantly granted, is it warranted in a case like this? And then I think overall, then there's the catch-all at the end of the variance provision, which says, overall, would this be a substantial detriment? I think that's another basis for potentially denying a variance in this circumstance. But from my point of view, it really comes down to, is this a unique situation? And then overall, is it a substantial detriment?
I don't know if you want me to address that at all. I think this is a textbook case where you have that interrelationship between the hardship and the unique conditions. Because of the topography, the town located its stormwater management system here. It had located that 50 feet down the road. Then this tributary would not exist on this property. This property would not be within the Water Resource Protection District, and we would not be in front of you for a variance. So I think it's almost a textbook case of that interrelationship.
Do you have any comments?
Most of the questions were answered, but again, the town was requested and granted permission to put that in.
Yes, for
$55,
$1 consideration.
So
yes.
it wasn't.
At a time when the notion of public water supply protection, I'm not saying didn't exist, but there was no regulatory scheme in the town of Scituate at the time that would suggest that somehow allowing the town to put its stormwater pipe on your property would somehow prevent that lot from being
buildable
50 years later.
Right, I mean, the intent certainly in the past was to maintain it and have it as a buildable lot.
Yes,
Seems.
and in fact, if you go back, and I explained this earlier, the easement was relocated, or the original line that got replaced was in the center of the lot. It was relocated to that end of that lot. And again, I can only make this inference, I don't know this, I have no personal information. It was relocated to the I guess that's the southern portion of the site. And the inference is that was to create the buildable area for a house, so that if the town needed to go and maintain the line, they wouldn't be digging up someone's driveway or going beneath that foundation. So, I mean, I think the clear intent here was not to preclude the development of this lot for residential purposes. It just didn't get done.
Two questions on that line. If the closed pipe, if the conduit were extended along the neighboring lots to the naturally occurring waterway, tributary, would it be considered a tributary were it closed by definition?
We don't think so. So I guess your question is, if the town went out there and extended the pipe some distance so that we were 150 feet away from where it daylight, I think that we would be outside of the Water Resource Protection District.
Second,
But having said that, trying to undertake that, and, you know, this property is now owned by other people. I'm not sure whether that could ever successfully be done.
but maybe good for the town, but it's, the other question, could the town be in a situation where they have overburdened the easement by creating a non-buildable lot? Is the town, if the applicant doesn't receive the relief they're seeking for the reasons that are by statute appropriate, could the town be in jeopardy of having overburdened the easement? Perhaps. I know it's a legal decision, but
Conceptually, you're correct, but we don't want to be in land court with the town of Scituate.
no, I understand. People do overburden easements. Individuals do, towns do, and others, and I know that they can be made to withdraw their use of an easement if they are perceived as overburdening it. I'm not suggesting that's the applicant's intention. I'm just suggesting that the reason the Zoning Board of Appeals exists is to understand when unique situations occur in order to balance the needs of all parties.
Mr. Vogel, do you have anything to add?
Well, it's a very complex question, as everybody realizes. I've done as much homework as I can, not being an attorney. I would have a hard time at the bottom of the debate granting a variance in this situation. I know that's a decision that's, going to make some, or a thought that's going to resonate with some people and not with others. The tests are the uniqueness, the possibility of financial harm or other difficulty for the owner, whether or not the variance can be granted and not derogate from the intent of the original bylaw. I think a couple of things occur to me. The Water Resource Protection District was put in place with no intention of somehow going back in time and recapturing property that had been already built on, which now ended up in the district. This property had not been built on. It seems to me that the Water Resource Protection District was put in place to prevent further development of land within the district. I mean, that's really all you can do. And that we've got a long and difficult situation on the other side of the same tributary at White Ash Farm, where the developer of that area was held to the strictest interpretation of the requirements of the Water Resource Protection District. So that's one thing that occurs. Bobrowski, which everybody seems to think is someplace to look for accurate information on these matters, seems to be speaking about some sort of harm to the applicant that could occur from not receiving the variance as different from financial hardship or even emotional hardship, but that it doesn't really have to do with whether or not there's a loss of potential value in the property, for example, and some other wording. So I don't want to babble on too much. I wrote this all down, and now, of course, it's rattling around in my head. But there are a lot of reasons that I think, you could consider not granting this variance, very honestly. Finally, one small note is that the land's been valued in the assessor's office at a value that would indicate it's not considered a buildable lot. And so, again, that may be something to think about and may or may not be significant, but that is the situation. So with that, I guess I'll leave it. But my feeling is it's overall that it's a difficult leap to say that a variance is warranted in this situation.
The only point I would make is, as I cited to Mr. Volkowski's book in my December 30th letter regarding the issue of substantial hardship, and I provided you with all of the leading cases which demonstrate that preventing a property owner from using a property for a conforming use is by definition a substantial hardship. So I think that issue is clear. With respect to whether the variance may be granted without substantial detriment to the public good, which is the standard, there is relevance to the Board of Health granting the septic permit, because the issue here is environmental protection, and it's kind of odd. It's not your typical zoning issue. And at least from our perspective, we thought that the Board of Health, which reviews these systems regularly, was best qualified to address the issue of environmental protection. We understand that it's a separate and distinct permitting process under a different set of regulations, but there is some relevance to the town's Board of Health determining that we had met the standards, the heightened standards, in order for a reduction of that 200-foot setback from the total bond.
At this point, I think...
I have just a couple quick questions.
Okay.
I guess, maybe Craig, there are dry wells for all the roof drainage? Is that what I see on here too, proposed?
Yes, we filed a full stormwater permit on this project previously, and it has roof dry wells attached to the roof, a rain garden attached to the driveway runoff to handle stormwater issues.
So those two things take care of, say, the runoff from the roof and the driveway, and the septic, again, you've addressed with the FAST system.
Yes.
That's it.
Right, now, obviously compliant with, the town's adopted its own stormwater bylaw, which has adopted the Massachusetts stormwater standards, which by themselves address water quality, water supply, infiltration, things like that. And we meet those stormwater standards by virtue of having our stormwater permit. That's an excellent question.
At this time, I think we'd open it up for questions to the public. Sir? Yes?
Good evening, my name is John Clarkson. I'm chairman of the Scituate Water Resources Committee, and we worked with the planning board to have the Water Resource Protection District passed. I first of all want to appreciate all the thoughtfulness that's been going into this discussion. It's good to see. I appreciate it very much. I bumped into the television presentation, the recording of your last discussion, and Mr. Hallen, the last time you and I were in a room together, I think our hair had color. I hope you're doing well.
I think you're right.
See you again. I want to address a couple of issues. First, Mr. Lynch, I think you addressed it very well. Do not be distracted by the fact that the proponent before you is talking about the fact that the septic system is very good, that it reduces effluent. The Water Resource Protection District, and Chairman Tracy, I think you discussed it very well at the opening. At issue with the Water Resources Protection District is this is a no disturbance zone. Do not diminish, do not leave it better than you found it, no disturbance. And with the septic system and the building property, literally all within the no disturbance zone, we feel that this variance should not be, the Water Resources Committee, this variance should not be approved. Let me also address another issue. There has been a lot of discussion about the stormwater, all right? And understand that When we had the presentation, you know, we left the meeting and other members of the committee are here tonight. Did they put the conduit there because of the topography and maybe because the conduit was there, a tributary formed? Or they put a conduit there because a tributary was there and they were putting it in? This is a chicken and egg discussion. None of us were around in the 60s. I'm not going to try to answer it. I will point out that back during the 60s, or whenever Country Way had stormwater put in, stormwater was a public safety issue, not a public health and a water quality issue. The idea was to get water off the pavement as rapidly as possible because our great cars, the 1960s muscle cars, it was a risk to hydroplane. So get the water off, channel it. There is now new research and a better understanding in recent years, past 20 years, that stormwater is a pollutant. And in fact, because of the development, White Ash Way, that's going in, the developer has made a payment or is making a payment of mitigation funds to the town to take that stormwater system that's currently feeding this tributary from whenever it began and will be replaced with a storm scepter system. And so the town will no longer, at least, be contributing to the pollutant of the area because of the stormwater runoff. What I've handed you is an email I have from the DPW engineer who's working on the installation, design and installation of the new stormwater. So this stormwater conduit that they keep pointing to is not going to be an issue very soon. And so I appreciate your taking that into account as well. What they're going to do, my understanding, is remove the daylighted conduit up to the 150-foot area. The town itself, when it redoes the stormwater area, is not even going to enter the 150-foot non-disturbance zone. So I want to make sure you keep that under consideration. The question I was going to ask earlier, just for the public's sake, Greg spoke of the R1 and the R2. Is the R1 the 150-foot zone and the R2 150-foot zone, or did you interpret that as other areas in the Water Resource Protection District? Is that the same as the 150-foot buffer?
150 feet is measured from the edge of the bank of the tributary, regardless of whether you're in the R1 or the R2.
Right, but okay, but when you put up your map, you were speaking of the R1 and R2 fingers. You didn't do an overlay of what houses were in the 150-foot zone. So I was a little concerned that, to me, that was a distraction. What's being discussed tonight is whether they can build a property in the 150-foot no disturbance zone, and the Water Resources Committee says, please, no disturbance.
Thank you.
Mr. Sis, could we respond just very briefly, because again, I think there's some misunderstanding. The storm scepter proposed treats total suspended solids, TSS, which is essentially sediment. It's not designed to treat pollutants that may be in stormwater, such as polyaromatic hydrocarbons. So if indeed there are pollution constituents in the stormwater, the storm scepter is not going to treat it. And with respect to the history, we have a piece of information that may be helpful.
Yeah. With regards to the tributary, Mr. Clarkson brings up the point of whether it exists in a natural state prior to that pipe being installed or not. As part of the 305 Country Way project, the town hired Steve Ivis, a wetlands consultant, on behalf of the town to examine that tributary area and to determine the wetlands that are associated with it. Mr. Ivis found that there were no upgradient wetland resource areas that are tributary to this lot. Mr. Ivis found that in that location there were no wetland plants associated with this lot. That being said, and with this lot being entirely upland area, there is no hydrographic features that would feed any sort of natural tributary that would have existed here prior to the installation of that drainage pipe.
And wasn't this lot identified as being totally wetlands on some town map?
You are correct. On the
And-
Mass GIS maps and on the town assessors maps, which may be the reason why the assessors had it appraised at a low value, I brought a copy of the current Mass GIS map. It shows that this lot is entirely, essentially, wetland area. We know that's not true because, again, the town has hired a wetlands consultant on a lot at the corner of Williamsburg and Country Way to review it, in the Conservation Commission approving it, that there were no wetlands on the subject property. So the previous mapping on GIS and with the town is inaccurate.
Oh, I'm sorry, ma'am, you can't do that. If you have a question, you have to raise your hand. Yes.
Sorry.
And you have to, please identify your name and address.
Sorry, my name's Martha Cook. I'm on the Water Resources Protection District Committee. I thought I understood him just a second ago to say that Steve Ives looked at 305 Country Way and said that was not wetlands. Did he also look at this one?
He walked up the tributary channel up here, and it was determined that it was a tributary and not a wetland area, a wetland being fed by groundwater and hydrographic features. He did not find that in this location. He found that the only discharge to this point was stormwater.
Yes, sir.
My name is Lance Van Lanson, 150 Old Oakenbucker Road. I used to be on the Water Resources Committee, and I was on the Water Study Committee. I, along with my wife Christine and Bill Crusell and a number of other residents, did a DEP-funded study of the watershed, and we reviewed tributaries in the field, and we did look at this tributary, and it's largely a natural stream. In fact, sections of it are perennial as it gets closer to the reservoir down gradient. The fact that there's a culvert there and somebody may consider that there's no wetland there is not important or not relevant to this situation because it is a tributary. And as Mr. Clarkson pointed out, we can't go back in time before Country Way was built and see whether or not there was a natural stream there. I know there's a map dated 1839 that shows a stream coming from that direction directly into where the reservoir was eventually built. So there have been a lot of changes, and tributaries have been altered by culverts, by roadways, all kinds of things. The point is, somebody from DEP came to this specific tributary, reviewed it, and confirmed it. And he confirmed it based on the fact that this tributary has been shown on maps since 2004. Mass DEP, as a result of the work that we did in the field, created a map that was disseminated to every board in town and became official Mass GIS data. So anybody who uses that data for developing a piece of property or just reviewing environmental issues can see that tributary has existed on a map waiting to be verified since 2008. So I think it's an important waterway that needs to be protected because it has a direct flow into the water that we drink. And I don't think you should disturb that area at all. I mean, it's just, and we, speaking for the group, and I totally agree with Mr. Clarkson and Mr. Vogel. Bill Crusell and I attended every single one of the 305 White Ash Country Way White Ash Farms hearings. And we were thoroughly impressed with the work that the planning board did to protect that tributary by enforcing that 150-foot non-disturbance zone. And we hope you do the same. Just one more little thing I'd like to mention. I was on the Open Space Committee with a number of people in the town. We did a project for the selectmen, and we reviewed parcels throughout the community. And we drew colors on old assessor maps and determine what areas might be sensitive. Today, we have the capability to actually come up with data that will tell you specifically what properties in town are currently within the non-disturbance zone, within the 200-foot zone A, and would be influenced by a change that may happen by granting a variance. I believe it would be a precedent, and it shouldn't be a precedent that's limited to its effect just in the R1 district. It would affect the R2 district too, because a precedent could be used for many other situations. So I hope you deny the variance. Thank you.
Laura?
Thank you.
And first of all, welcome to our zoning board. This is the town planner, if anybody doesn't see you from behind on the thing, so.
I think everyone would agree we want to make progress with protecting our water supply. There's a tendency as development continues for the surface water in particular to degrade from stormwater, which carries, through the total suspended solids. Those carry hydrocarbons and bacteria and other substances into surface waters, and I think that's one of the reasons why the vegetative buffer was so important. I think many methods are needed to do this, not one versus the other and the 150-foot buffer is one which town meeting back in the 1980s agreed was a good method of doing this. There certainly is room to change the zoning. We just went through a town meeting and zoning was changed. So if the applicant and other property owners with property in the Zone A believe that there shouldn't be a 150-foot buffer, I think there is the avenue of going to town meeting to change the zoning. I want to mention that there's been a lot of discussion about how many lots are in the Zone A's and what part of the Zone A should be considered when you're thinking about the uniqueness of a particular lot. The Zone A, I'm assuming that the Water Resource Protection District is the district that you're evaluating when you're looking at the uniqueness of a parcel. And the Zone A is kind of basically just shows where the tributaries are because it was taken as a 200-foot distance around the tributaries. So those tributaries go all over town. They're not just in the R2 district. I don't know that there are any in the R3 district, but they're all over the R2 and the R1 district. When I did some analysis on this, I asked the Metropolitan Area Planning Council to overlay the Zone A's with the assessor's data for all the lots in town. There were actually over 400 lots that had some area within the Zone A's. Many of those were already built on, but there were a significant number that had one house and additional buildable land where you could economically have a good development situation by tearing down that house and developing the back land. It would make a difference in how those properties could be developed if that Zone A is considered with a tributary or with a 150-foot setback around the tributary or not. When the lots owned by the town of Scituate and the lots without any frontage and a number of other situations which under zoning made them unbuildable were peeled away. There were about 50 lots left in the Zone A, with some property within the Zone A. And of those, the ones that had the most obvious land that was pretty much completely within that 150-foot buffer were all within the Williamsburg Lane area. Some of those could be wetland, but as we've seen with the Williamsburg Lane parcel, sometimes those wetlands do tend to change over time. There are mapping issues. There could be land which is some upland on the lot, which could be identified and could be buildable. So I think the analysis of exactly which properties are buildable by other criteria isn't necessarily important. I think the important criteria is that 150-foot buffer. And let's see, so just one last point to reiterate some of the things that Bob Vogel talked about. The planning board had 12 meetings on the White Ash Farm property. About 4 of those were almost entirely involving the tributary. The planning board got the tributary surveyed, as it happens, by Greg Morris, the same surveyor and engineer who's here with you. They wound up getting the land within the 150-foot tributary donated to the town because it was considered unbuildable and because there was a desire to protect it. The road was moved outside of that area. There was just a great deal of work involving that tributary. The storm scepter was another piece that was related to the discussion on the drainage and how to better handle the town's drainage. So I think the planning board spent an awful lot of time trying to uphold this bylaw and support it with the idea in mind that it benefits the town's water supply and really should be supported. Thanks.
Thank you.
Mr. Z, could we just provide some additional information?
Sure.
If appropriate. I just want to be clear that whatever stormwater is associated with this project is minimal. It is being managed on site. We're maintaining a vegetated buffer for any stormwater could actually migrate off-site and potentially get into the tributary. Ray can give you the watershed that you evaluate. It's going to be infiltrated, and so it is it's more than highly unlikely that any stormwater from this property is going to ultimately end up in that tributary and somehow impact the public water supply. So with respect to the 305 Country Way, it's a different project. They had sufficient area to respect the 150-foot buffer zone. If we had sufficient area to do that, we would gladly do that. We can't because we're entirely within that 150-foot buffer zone, which is why we require a variance. We're not trying to derogate from the purpose of the bylaw in any respect. We have no choice because if you deny the variance, this lot will then be unbuildable. That's right. I don't know if you have anything to add on stormwater.
I mean, the stormwater was reviewed by Conservation Commission. As Adam said, it is directed into infiltration devices. Again, the dry wells, the rain garden, we have shallow swales on the site. And what we tried to do is we tried to minimize the impervious surfaces. The bylaw allows a maximum of 15%, which is 3,219 square feet of the lot to be impervious. We're under that with 3,025 square feet of impervious surface. We're not maxed out in that regards with the bylaw either.
Anyone else from the public? Yes.
Hi, my name is Samantha Woods. I'm the executive director for the North and South Rivers Watershed Association, and we submitted comments just this afternoon. I just wanted to make a few points. First, the Watershed Association has been involved in the area in protecting these streams since 1970. A lot of the work that we do is to support citizens going out and collecting field data so that we can provide information to decision-making bodies on how they can best protect and improve their water resources. In fact, the work that was done by Lance's group was supported by the North and South Rivers Watershed through a grant from the Department of Environmental Protection and led to the discovery of many new areas that contributed to your water supply. Well, they weren't new, they were undiscovered, let's put it that way. Your water supply, we've worked with your Water Resources Committee to better understand your water resources. I would say your water resources are strained. I think we all know that from the restrictions that you have. And we know that no longer support certain species that have been there before because of those strains that we've been putting on the natural system. We're working hard to help the community to try to lessen the strain on those resources. You have a very strong Water Resources Protection District bylaw, one that is grounded in science. There's a reason for the 150-foot buffer. The closer you come to water, the less filtration you have for potential for pollution. And while I understand that the situation for you is somewhat difficult, the fact is that when we develop near a water body, we have less control. That's why you have these buffers, because as soon as we, as humans, put our footprint down on that land, things happen that we even though we may have good intentions and we have very good engineering solutions for some of the issues that we have here in terms of sewage and septic systems and stormwater, there are some things you're not going to be able to control. Whether or not people put chemicals on the landscape, what they put in their own bodies and then flush down that toilet. Those are things, that's why we have this buffer. It's a protective measure. It would have been great if we could have had it before, we had developed all this land, but we didn't. And so now the idea is to try to raise the standard for everybody and to allow as much filtration into the ground and let nature do the best that it can to take out those pollutants. I'm just going to share with you an example of what happens when we allow development next to a water body. There's one right in your town. There's right on 3A, there's a property that's developed right next to the Tack Factory Pond, which is a reservoir. It has an updated system, septic system. It was built before the reservoir was in place. So the good news is they've updated what was probably a failing septic system by putting it in a mound and putting in a fast system, which I agree is good. But subsequently, owners transferred, and subsequent owners have put a tree in the mounted system, planted a tree. I'm sure, they didn't understand or know that that was potentially harmful to the septic system. So now it's incumbent upon the town to have to try to get that owner to take the tree out. I have yet to see the tree removed. So I think the problem becomes you don't have control. You lose that control, and your town doesn't have the capacity or the mechanism in place to be able to go in on a private property and start micromanaging it. And so you open yourselves up to risks that, were the reason for the buffer in the first place. So I just wanted to bring that sort of story to you because I think you want to, internalize what that really means when we're talking about the buffer. And then in terms of the sort of man-made versus not man-made business, I agree that I don't think it matters. The point is now you have a tributary. There are a lot of man-made water features in your water supply, all of them probably at this point. Your reservoirs are man-made, so does that mean now that if there's a property next to the reservoir, that it somehow could be developed outside of this buffer zone, within the buffer zone? Because it was man-made, I'm a little confused about how that could work in the future for you. From my mind, as a scientist, water moves, the landscape changes, and you need these protections to move with it. That's, hopefully the flexibility that you can have. So the Watershed Association that I represent would like to ask you to deny this variance because of those reasons. Thank you.
Anyone else? Okay, any further questions first from the board, then we can do comments. A question?
No.
All right, so, I haven't said anything yet, so.
I'm waiting for you.
I know, so let me do mine. First of all, I want to compliment the applicant and everyone that the applicant has hired. You've done a great job representing your client. You've done a great job in presenting your issue and advocating for it. I also want to very much compliment everyone in the audience and the public who has submitted comments, whether they're by email or coming here tonight. You have all been extremely respectful and intelligent, thoughtful, and have really considered what you have to say and have said it very well. That's not always easy when it's a very passionate issue, which everyone here is clearly passionate about their concerns. So it's very nice to have such extreme disagreements, but everybody being able to present their argument in a intelligent, reasonable, and informed manner. I'm going to kind of go back to one of the very first issues, Adam, that we talked about the very first time this meeting, and I remember saying to you, what district are we talking about here? I personally have probably spent, and I'm a slow learner maybe, but 30 hours on this. I read every case, I briefed every case, I felt like I was back in law school, briefed every case you gave, went to Brabowski, pulled up some additional cases, looked at maps that were provided by you, by the town, by some of the other citizens, and gave great consideration to this. I think, I have come to believe sincerely that this is probably one of the most serious issues in applications that has presented itself in front of this board in a very long time. I think it's a matter of public safety. I put it right, I'm not sure I'm going to say put it right up there, but I felt very strongly about the cell tower issue too. It was a highly contested issue, but it was a matter of public safety. This, to me, is a matter of protection of our water resource protection district. It is something that was voted into this town in 1987. It deserves our careful attention and careful consideration, which is why I spent so much time on it. But going back again, the question I had in the very beginning was, I was a little confused, wasn't sure, are we really talking about, when we're talking about your property, is it the R2 zone that we're talking about, or is it the Water Resource Protection District? And the conclusion I have come to is the only logical district we can be talking about is the Water Resource Protection District. There is nothing about any requirement of R2 district that you are seeking relief from. And I know you got it up there because you got the statute ready, but I looked too, okay? And it talks in our bylaws, the definition of zoning districts at 340. And the Watershed Protection District, Floodplain and Watershed Protection District is listed as a zoning district, okay? I think that has to be the district we're talking about. That's the relief you want. You want some relief from that. The concern I have is the fact that the whole property is within that 150-foot buffer zone. And I think, as Frank talked about it and Mr. Clarkson talked about it, I think I got a little distracted initially for the whole idea about the septic system, that you had made such efforts and had come with the design for this fast system. But you're seeking relief, you're gutting the whole Water Resource Protection Buffer Zone District bylaw. You want relief from every aspect of it. And it would be so much easier if we were just talking about a lot smaller area with one little issue. But we're not. You're going to have to move earth, you're going to have to, that's a completely wooded lot, everything's going. You're going to put a permanent structure, and you're going to have a subsurface discharge. And it doesn't say subsurface discharge that is, that cannot be protected by, adequate engineering. It says you can't do it, okay? And when you talk about what is the purpose of the bylaw, you read something, but I'm looking at the purpose of the bylaw: to preserve and maintain filtration and purification capacity of the land, groundwater table, purity of groundwater, surface water supplies, to conserve the natural environment, and to protect the public health, safety, and welfare, and to comply with state law. By seeking relief from every aspect of that bylaw, I think by definition, my concern is, and I'm kind of jumping to the end here, that it does denigrate the bylaw. But let's.
Could I respond just briefly?
No. I want to get going. You get right there. I know.
Factually.
Okay. That's fine.
We're not seeking relief from the other provisions of the bylaw, in particular the dimensional regulations.
You're seeking it from the buffer zone.
Oh, that's the one provision. You said
There's 4 things in it. 4 things.
There are a number of requirements within the bylaw.
We're talking about the buffer zone. I agree we're talking about the buffer zone. No, let me go on.
Okay.
You'll have, you've talked on that.
I just,
Okay, no, I know. So I still go back to, let's start again. We're talking about the Water Resource Protection District. We've heard from Laura that she located some 50 properties, okay? I spent time with town maps trying to locate each of these properties and kind of say, well, were they they might have been within the 250 feet, were they within the 150? A number of them weren't. A number of them I couldn't even find, okay? I don't know. But I did find in that neighborhood 11 lots, okay? 11 lots on Williamsburg, Bruton, and Christopher Wren that were within the 150 feet of the tributary. And that's right around the corner. And the property owner, I think you know, is on 9 of those lots is Bargazone. And I'm sorry if I mispronounce your name. So I'm having extreme trouble getting beyond that this is not unique. This is not a situation where this is the only property. I don't care how that tributary came. I don't think that's the issue. I don't think the issue is that your lot slopes a particular direction. That's not the issue. The issue, and the sole issue about the uniqueness of this lot from other lots, is that it's near a tributary.
so I've done apparently a poor job of explaining.
You have not, but
So
you have
let's
done
start from the beginning. When we first came.
No, okay,
Oh,
no, I'm not done yet. I'm not done. I
Let me
have
have a
some other
chance,
talks I
please.
got. You'll get your chance.
Okay.
So I can't get you past the first one. I've tried very hard, and I've thought about it and looked at it and tried to make common sense approach to this issue. And the issue is that we're talking about the Water Resource Protection District, and we're talking about properties that have not been developed, that are within the 150-foot buffer zone, that have a potential. And we don't know if they all do, okay? But there is no doubt in my mind that if this variance is granted, I know 11 lots that are going to be looked at far more carefully. And the fact that they are currently maybe on a paper street and the other street hasn't been, hasn't been developed, I can't get to the uniqueness of it. That's my problem. And then, we go to the other standards for the variance, and reminding all of us that it's not us to prove that it is not worthy. It's your job, the applicant's job, to prove that you're entitled to the variance. And I read Grabowski all about the hardships. I read all of the cases, okay? And so one of the cases even you cited says if and we've had these cases in Scituate that have been appealed, that a bylaw prevents building, and so nothing can be done. But sometimes that's the way it is. And that in and of itself is not a hardship. This was property that was once owned by one individual who developed the whole area, who did very well in developing most of the houses I shouldn't say that, many of the lots that are in that area. And some of the lots were not being developed. I don't exactly know why. It's not an issue why the rest of the lots in Williamsburg weren't developed. It's not even an issue on why this one isn't. It's the only issue is, do today we look at it and grant the variance to allow it to be built on? And as much as I have looked at it, I don't think that, I don't think you meet the second half of the first prong for the standard of variance. So I don't get to the hardship issue. I think that the point of the bylaw and the fact that you were in the buffer zone, you're doing all of the things. You're moving earth, you're removing vegetation, you're constructing a permanent structure, and you're discharging wastewater. And again, it doesn't say wastewater that can't be adequately engineered. The fact that Conservation might have given you their blessing, the fact that the Board of Health might have given you the blessing, it just doesn't factor into my analysis. They have a whole different set of standards. Maybe they should, maybe it should have come here first, I don't know, but,
Well, it didn't have to come here first until
No,
it
you
became a
didn't have
tributary.
to.
Until it became a tributary, it didn't have to come
it's
here.
always
That was
been, I think,
No,
somebody said,
until it was
it
identified.
wasn't, yeah, but it still existed, it discovered perhaps, just like Lewis and Clark.
The reason we went to the Board of Health first is to demonstrate that we were providing appropriate environmental protection, which goes to the substantial detriment to public good. If the Board of Health wouldn't reach that conclusion, we wouldn't be before you with respect to variance. Second, the bylaws, a number of requirements, only one of which is a buffer zone requirement. We comply with all of those other requirements, including the dimensional regulations in the bylaw. So we're only talking about relief under the buffer zone. Third, the uniqueness is not the fact that this is an unbuildable lot within the Water Resource Protection District. The uniqueness, you may remember, is the fact that we've got this unique topography. When we originally presented this to the board, we were addressing the Water Resource Protection District. And Greg told you that he is familiar with the district and he has not seen these unique topographic features within the district. The board asked us about, well, what about the underlying zoning district? Because it is an overlay district. The requirements enumerated hereafter for the Water Resource Protection District shall be in addition to, rather than in place of the requirements for the underlying district. So my recollection is the board asked us to take a look at the underlying zoning district, which is why you have this additional presentation here. But the point I'm making is, it's not because it's an undeveloped lot in the Zone A, it's because you have these unique topographic features which we think is a reasonable inference that caused the town to put this stormwater pipe at the lowest point of the system, thereby creating the tributary. And Greg has told you, he is not familiar with any other instance where you've got those two streams coming together at a low point in the municipal stormwater system where the town has created a tributary. So I've done a poor job if we've gotten off topic on talking about the underlying zoning district. We thought we were being responsive to this board. But the original presentation to you addressed originally the Water Resource Protection District. And Kenley, I thought that we had satisfied you on that. And
I think you did good your job, and I told you, maybe I'm a slow learner, but when I come down to it, the uniqueness that really, the issue on this lot that prevents it from being a buildable lot today is because you're 150 foot, you're really totally 100, well, you said that, that's, I mean, but that's what I see. Because it goes this way?
yes,
I mean,
absolutely.
I mean, if you have that, first of all, I haven't seen a single case, okay? It's almost like saying, you could come up with, well, if that's unique, you could come up with, well, it happens to be the only lot with, 5 pine trees smack in the center. But that's
No,
not the point.
but that
The
would
point
not
is you
satisfy the
are
statute.
within 150 feet of a tributary.
As a result
That's
of
what's
the-
preventing you from building.
And I don't mean to argue with you. I respectfully disagree because you're jumping to the wrong conclusion. It's the unique conditions related to soil and topography, not vegetation.
What about
Not-
soil? What's the soil? They see soil, they talk about clay that you can't build,
We're
or
not
shale.
relying upon soil. I was just saying that soil, topography, or lot shape. This is an issue having to do with topography and to a certain extent lot shape, because given the shape of the lot in relation to the fact that we have this unique, we're at the bottom of that bowl of that stormwater, of the stormwater system that creates the physical conditions, which is why the town put the pipe there that created the tributary.
Sarah, can I ask a question for a second?
You sure
Just
can.
Give you some relief.
Thanks.
This is you convinced me, I think I told you this the last time, that it's got some very unusual, perhaps unique topography. I mean, I'm sure there are other lots that have a slant somewhere in town. But to me, that's not the issue. The issue is then what is it preventing you from doing? And the case talked about where there was a ledge and they couldn't build to the height requirements because of ledge, or another situation where because the soil wouldn't support the structure because it was an unusual soil in that circumstance. And here you've done a great job of pointing to this unique feature that may probably have caused this tributary, but it's the tributary that's preventing you from being within, that's putting you within the buffer zone, and it doesn't matter what caused it, really.
Well,
Because it has to
you need
be-
to show a nexus between the unique conditions and the relief you're seeking. And I can't think of a better case, because we have these unique soil shape topography conditions. Excuse me, I'm getting tired, it's getting late. We have these unique conditions relating to topography and lot shape. And reasonable inferences, that's why the town put the drainage pipe there, which led to the creation of the head wall. Because they did that, and the town, 20 some odd years later, then adopts a bylaw, which, well, actually, it was not until 2013 that was declared to be a tributary. That it's as a result of that you now have to deal with 150 foot.
If it wasn't a tributary,
nexus
just
between-
answer this, if it wasn't a tributary, and you had this unique condition, would you be able to build or not?
But we don't need relief because we otherwise comply with
Would you be able to
zoning.
build or not? Yes, right? You would, because the only thing that's stopping you here is the fact that it's a tributary. It's not the fact that there is this unique topography.
Well,
It's unique.
You're holding me to a different standard. So you're saying in one respect that you've got to comply with solely the Water Resource Protection District bylaw, but you're now bringing to the argument, well, you've got to, can you get other kinds of zoning relief? This lot complies with zoning in all respects except with respect to the Water Resource Protection District. We don't need a variance. So to suggest that because we have those lot shapes that we need a variance, I don't think is a fair.
No, and that's not what I'm saying. What I'm saying is that I don't see the cause of the tributary as being what the statute is talking about as requiring some unique topography or unique soil conditions. The statute is talking about how the unique conditions prevent you from building something that would otherwise comply.
The statute was drafted to deal with your typical dimensional and lot area requirements. 48 Section 10 predates the adoption of water resource protection by, I don't know, when was the original zoning act adopted in Massachusetts?
Well, no.
You need to adapt it to this modern.
The statute was
water-
adopted in 75, I think.
Was recodified.
I thought it was in the.
No, when I was reading,
I mean, zoning was adopted, in the town in the 50s, so the zoning, some form of the zoning act existed
Right,
at that point.
but the variance provision was changed substantially in 1975. I think, if I remember, it was only 6 hours ago that I read this.
Prior to the adoption of the town's Water Resource Protection District. So we're
Right.
trying to compare kind of apples to oranges. I mean, I just want to point out that, and you may remember this, back in February, I made reference to the state adopting, and let me make sure I've got it correct. The state adopted the new Watershed Protection Act, 92A and a half, to regulate land use within the Quabbin Reservoir, the Ware River, and the Wachusett Reservoir, and that was adopted 2012, so the latest version. And in that, there are express provisions having to do with variances for the construction of single-family dwellings on lots existing prior to July 1, 1992. Actually, there's an exemption for that. So the state, when it goes and drafts its brand-new, water supply act relating to, the Quabbin Ware River and Wachusett Reservoir, the states recognize that, boy, we should have grandfathering in our, because, sort of the typical zoning variance doesn't really, the analysis, I don't think, really translates well. We don't have the benefit of that. All we have is your variance provision within your bylaw. And so I respectfully suggest that it's hard to draw analogy to your typical variance cases. We're not dealing with a lot area issue. We're not dealing with a setback for a garage from a sunline setback. We're dealing with this kind of environmental protections that are now regulated as part of zoning. So I think you need to suggest you need to be a little bit more flexible in how you do this. I think that our reasoning holds true. That tributary is there because of the unique topographic conditions that relate to this lot only. The town put that tributary there. As a result, we have the buffer zone. And absent a variance, we can't get relief from that. We can't develop this lot for a single-family home, which is a permitted use within the district. So I think there's a direct logical connection, as Bobrowski would call a nexus, between the topographic features here and the relief received.
I'm sorry, we closed discussion to the public, so, but, I think I'm just in the same as Frank. You know, if we, I think you can conceptualize that every piece of property in town that is an undeveloped lot within the 150, within the 150-foot buffer zone says, well,
You would need something more. We can see that, sir.
You know, but all lots, when a tributary, the banks generally, you know, go down. It just happens. I'm just...
It is not...
And you know what? I'm telling you, if you take it up, you know, if I'm wrong, I'm wrong, but I don't think I'm wrong. Any other comments by the board?
No, I mean, just, it's been a tough argument. I mean, there are certainly, I understand where Adam's coming from, but at the other end, it's pretty clear on this, on the non-disturbance zone, we haven't got any piece of property outside of that. So that's the part of the tough part for me.
So let me ask, is there any additional information that we could bring to bear on this for your
No,
consideration?
I honestly, I mean, you may not, you know, because I personally don't see it, it doesn't sound like Frank sees it quite the way, doesn't mean you haven't done a great job. I mean, everything that we've asked for, you provided. You know, I think you've done as good a job as you could possibly do. You've certainly, but I think we just simply see things a little different. And when I come right down to it, I think that, you know, for me, the final puzzle, the final piece of it is that I don't think, despite the fact that you have designed an amazing septic system, the mere cutting of the trees, the mere moving of the earth, the mere placement of a permanent structure on the property, the reality that, you know, has been stated by a couple of people, and as I said the last meeting, you cannot expect that somebody you ask for reasonable accommodation, a reasonable restriction on use of pesticides. You can't, that is absolutely unpoliceable in town. It just is unpoliceable.
Well, if I might, other boards in town place conditions on projects, and we're required by law to comply with those conditions. It's black letter law. You can't deny a project for fear that someone may not comply with a lawful condition and therefore result in enforcement.
Well, that's not the reason you might get denied. It's just another, for me, it's another piece of the puzzle.
The point I would like to say is that we've not heard any scientific evidence refuting our testimony that there are going to be no adverse impacts to the water supply. We are maintaining a natural buffer. We're controlling stormwater. The principal contaminant concern related to the septic system is nitrogen. We've addressed that issue. I mean, it's, you know, we understand, and these are all well-founded concerns about what may happen, but there's been no testimony that anything that we're going to do on this property is going to result in an adverse impact.
And there's not required to be. We are not, no one is required, the board is not required to prove that there's going to be an adverse impact. You are required to prove. You know, you're cutting trees, you're moving earth.
May I interrupt you for a minute?
You may.
I find it interesting that both and I applaud everyone for all their input. But people tend to look at an application before the ZBA in a macro, and it isn't. The reason it's before ZBA is it's micro. Ms. Harbottle thoughtfully suggested that if you don't like a bylaw, you change it. Well, I don't want anyone touching the 150-foot or 250-foot or 10,000-foot setbacks that are set in place in the macro. That would be a horrible suggestion. And I hope that no one watching at home thinks that they should go and try to attack the Water Resource Protection District by making a change to the bylaw in the macro. But in the micro, that's exactly what we're here to talk about. And I think that it's important to understand the Water Resource Protection District is 520, not 520.4. It's 520. And if you read it in its entirety, it talks about the purpose being to protect the Scituate's water resources. It gives a listing of findings that within the area many human activities can occur that have been shown to contaminate surface water supply and groundwater use by public wells. And it lists them: accidental spills, discharges of petroleum products and other toxic hazards. Materials sewers discharged have repeatedly threatened the high quality of the groundwater and surface water supplies and related water resources throughout towns in Massachusetts, posing potential public health and safety hazards and threatening economic losses to the affected communities. And I could go through, and I don't want to be perceived as picking and choosing here. But clearly 520 is a macro bylaw. It's intended, and it lists uses and activities that are regulated. It lists 36 uses that are not allowed. None of them are residential housing. There's clearly concerns, for example, floor drainage systems in existing industrial commercial process areas and hazardous materials and hazardous waste storage areas which discharge to the ground without a DEP permit or authorization, et cetera, et cetera. And I don't want to start picking and choosing. I don't want to read the whole bylaw. It's extensive. The applicant is simply looking for relief from one small component of it, albeit an important one, of the buffer zone. But if you read all the rest of it, it talks about restricting flow of hazardous materials into our drinking water system. I would argue, and I'm not arguing whether there's a tributary. Once it was identified as a tributary, once it was discovered to be a tributary, it's a tributary. Nobody's arguing that. Where it came from, why it's there, I just find it an interesting question of debate or discussion as to whether or not granting of an easement and then the town's use of that easement and then an increase in water over that area. It's an unfortunate situation, but what we have today is a tributary. I'm not suggesting we can block off the drainage and have it disappear. It's still a problem. But again, looking at it from a macro, the other lots in the neighborhood are not, in my unprofessional or limited experience, are not developable because you can walk through them and you're knee-deep in water on half of them. They're not wetlands because of pussy willows growing on them. They're wetlands because they're wet. I mean, this one is not the same kind of a lot. The reason we're talking about this lot is because it's different. It is different. It's topographically different. And it's not because it has a slope. It's because the whole area goes to this one point. I think the applicant has made a good case for that. Having said all of that, I understand the concern for the sacrosanct aspect of the 150-foot non-disturb. I also appreciate that non-disturbance, if this lot were 70% out of that zone, and we were talking about granting development that allowed for a corner of the building to be within that zone, I would hope that there would not be this large turnout, because when one owns property, one has a right to develop it within reason. And that's what we're here for, and that's why this board spends so much time considering it. And that's why I've considered it, even though I was accused of being predetermined. And if I should happen to come forward and be in favor of the variance, it's going to be suggested that, oh, he had his mind made up. So I'm going into a little bit of explanation because I want you to understand where I'm coming from. This lot, the concerns voiced in 520 in its entirety are those of effluent from groundwater, from runoff, surface runoff, sewage, industrial applications. It goes on and on. And I don't think any of those concerns that are enumerated in 520 are going to happen as a result of developing this single-family lot. In fact, I think they're guaranteed not to be happening. If this lot should go undeveloped in the future, after the applicant exhausts appeals or whatever, I would hope that they might consider offering it to the town with the stipulation that the town institute a surface water runoff treatment facility that will save our water supply from the drainage that's hitting it from the highway. Because that's where I see our problem, not whether or not we put a single-family house lot on here. And frankly, within 520, it is allowed that construction or placement of a permanent structure associated with providing of public water could be done. And if that looked as big as a house, I'd hope to make it look attractive and fit into the neighborhood. But if it's necessary to clean up the water that's flowing into that tributary right now, I think that's a good move for this town. And I'd vote for that at town meeting and in every board that heard it. Because our groundwater, our drinking water, is at far greater risk because of that culvert that's going off of the roadway and into that tributary than anything that might happen that this applicant's proposing before the board tonight. I think the applicant has made a good case that it's a unique property. I don't think in the micro, talking about this lot, it's going to create a slippery slope for all other undeveloped lots to move forward. And I see members of the audience being bothered by the fact that I'm saying this. But when you own property, you have to have your rights protected in that ownership. And I'm not willing to give up the rights of the town's water supply for the individual owner of property. But we're here to listen to it, to listen to the debate, and I don't think there's been any evidence to suggest that what's being proposed here compromises our water supply. It is a unique lot. It's a variance. The granting of a variance is hard to come by. And in the micro, I think the standard has been met. Clearly, I'm in the minority, but I think we need to stop trying. I think the public needs to understand that you don't argue before this board in a macro way. Like, oh, we can't change the zoning if you don't like it. It's not the point. The point here is, in a given situation, can relief be granted reasonably to an applicant to make use of their property in a way that is customary and usual for that zoning district without undue or substantial detriment to the public good. We do it all the time. Usually it has to do with sight lines on highways or whether or not the house has to be closer to the road than is allowed under the bylaw. This is a tough one because it's talking about public drinking supply. But nowhere in the testimony that's been before us today or the last meeting has anyone shown me any credible evidence that our public water supply is in jeopardy because of the development of one house on this lot using a fast system. In fact, I think they've shown that they've taken great care to develop a plan that will protect our public water supply while allowing the owner to utilize this land in the way that it is zoned. So I think that you have to look at 520 its entirety. They're looking for relief from one section of it, and I think they've met the standard.
Okay. Does somebody want to make a motion?
Okay, if I might, unless, Mr. Trustee, you've reconsidered your position, we make a request to withdraw the application,
You wish to withdraw the application?
rather than getting denied, yes.
Okay.
No prejudice.
I'd move to allow the applicant to withdraw their application without prejudice at their request.
Second.
All in favor?
Aye.
Aye.
Thank you very much for your time.
Thank you. Got away from me.
Do we have minutes to vote? Do we have any minutes to vote?
They're going to wait till I'm dead.
The husband.
I didn't, nobody said it.
My biggest concern is that the whole thing was in the 150.
There are minutes? Okay. April, okay, I wasn't there when April.
Yeah, you responded to the email.
I responded, said I wasn't there.
Yeah, I read through.
I read them. I think they're fine.
Okay, we have to formally-
Motion
Still, are we still in
Yeah,
session?
we're still in.
Move to accept the minutes
From the April meeting?
from the April meeting as emailed and reviewed.
All those in favor?
Aye.
Aye.
I think I should be voting. I wasn't here.
Don't have to.
Okay, motion to adjourn.
Second.
Second.
All in favor?
Aye.
Meeting adjourned.
Are we off?
Yeah.
Are we finished?
I have a question, not about the case.
Yeah,
No, nothing to do with that.
Yeah.
Is your wife Sarah?
Yes.